I'm going to speak to you today about the juvenile death penalty in the United States. I chose to focus my discussion around the Supreme Court case called Roper v. Simmons. We are going to learn some history and what led up to this landmark decision, take a deep dive into the case, and finish off with my personal views. I hope you enjoy. Before we look at Roper v. Simmons, you need to know about some important rulings that came first. In 1988, in the case of Thompson v. Oklahoma, the Supreme Court held that imposing the death penalty for people younger than 16 at the time of the offense constituted cruel and unusual punishment, violating their Eighth Amendment rights. Subsequently, the Washington Supreme Court set the minimum age at 18, and the Florida Supreme Court set the minimum age at 17. In 2001, U.S. Surgeon General David Satcher declared the super-predatory theory a myth. In 2002, the United States Supreme Court held in Atkins v. Virginia that the United States Constitution prohibits the death penalty for intellectually disabled. Also in 2002, in re Stanford, the United States Supreme Court decided not to reconsider the issue over a strong dissent by Justice Stevens, joined by Justice Breyer, Ginsburg, and Souter. These four justices not only wanted to revisit the juvenile death penalty issue, but were ready to put an end to the shameful practice by declaring it unconstitutional. On December 8, 2003, the Kentucky governor granted clemency to Kevin Stanford, changing his death sentence to life in prison without parole. Finally, in 2005, in Roper v. Simmons, the Supreme Court of Missouri interpreted contemporary national data and held that the death penalty for juvenile offenders violated the United States Constitution's prohibition against cruel and unusual punishment and banned the death penalty for all juvenile offenders. We're now going to watch a short news video that came out at the time. The video quality is poor, but the information is good.
The majority opinion striking down juvenile death sentences was written by Justice Anthony Kennedy. He noted what he called the overwhelming weight of international opinion that has moved against the juvenile death penalty in recent years. Justice Kennedy also wrote that American society views juveniles as, in his words, categorically less culpable than the average criminal because of their lack of maturity and emotional stability. Reaction from death penalty opponents was swift and positive. Marcia Levick is with a group called the Juvenile Law Center in New York.
We cannot impose capital punishment on offenders who do not demonstrate the same degree of adult blameworthiness, adult culpability, mature judgment as adult offenders do.
The narrow 5-4 decision affects 19 states that had allowed offenders under the age of 18 to be put to death. The ruling abolishes death sentences for more than 70 murderers now on death row who committed their crimes when they were 16 or 17. The Supreme Court outlawed executions for those 15 and younger back in 1988. The United States had been among a dwindling handful of countries in recent years that still permitted juvenile executions. Other nations that have been moving to end the practice include Iran, Pakistan, China, and Saudi Arabia. Justice Sandra Day O'Connor wrote a dissenting opinion for the four-member minority. She argued that even though those under 18 may be less culpable for their crimes than adults, they should still be eligible for the death penalty depending on the severity of the offense. The decision was not welcome news for family members who have lost loved ones to teenage murderers. Bill Green and Adolph Pena both lost children to killers who committed murder at the age of 17.
Well, the person that killed our son had already committed over 14 felony accounts by the time he was 17 years old.
But I can tell you one thing, these 17-year-olds definitely knew what they were doing when they murdered my daughter.
The Death Penalty Information Center says 22 criminals have been executed for crimes committed when they were 16 or 17 since the Supreme Court reinstated the death penalty in 1976. The latest ruling continues a trend on the Supreme Court in recent years to restrict the use of the death penalty. The High Court banned the execution of mentally retarded criminals in 2002, calling it a violation of the U.S. Constitution's ban on cruel and unusual punishment. Jim Malone, VOA News, Washington.
It's important that you understand the basic facts surrounding this case. This case involves Christopher Simmons, who was 17 when he planned and carried out the murder of Shirley Crook in Fenton, Missouri. He was convicted of first-degree murder and sentenced to death. During his appeals, it came out that Simmons was very immature, very impulsive, and very susceptible to being manipulated or influenced. The experts testified about Simmons's background, including a difficult home environment and dramatic changes in behavior, accompanied by poor school performance in adolescence. Simmons was absent from home for long periods, spending time using alcohol and drugs with other teenagers or young adults. The contention by Simmons's post-conviction counsel was that these matters should have been established in the sentencing proceeding. Simmons lost the appeal, and the Missouri Supreme Court affirmed. Later, the U.S. Supreme Court held, in Atkins v. Virginia, that the 8th and 14th Amendments prohibit the execution of a mentally disabled person. Simmons filed a new petition for state post-conviction relief, arguing that the reasoning of Atkins established that the Constitution prohibits the execution of a juvenile who was under 18 when the crime was committed. The court agreed. The court determined that juvenile executions violated the 8th Amendment's provision against cruel and unusual punishment under the evolving standards of decency test. The state of Missouri appealed that ruling to the United States Supreme Court, which agreed to hear the case. I thought the best way to understand the legalese in Roper v. Simmons was to explore how this case got to the Supreme Court. In order to do that, we're going to take a look at a movement that was beginning in the United States. During the 1980s and 90s, concern about juvenile crime peaked. The term superpredator was tossed around, and many legal scholars and juvenile advocacy groups became alarmed at the wave of the harsh juvenile justice system reform sweeping the country. Youthful offenders were automatically transferred to the adult system. The juvenile justice system became increasingly harsh and punitive and lost its rehabilitative ideals. In 1996, the MacArthur Foundation established the Adolescent Development and Juvenile Justice Research Network, whose goal was to stem moral panic and reverse the tide. Existing research did not address the legal implications of adolescent developmental immaturity with respect to competency, culpability, and capacity for change. The ADJJ Research Network engaged a team of practitioners, researchers, and legal scholars to ask questions that were legally and morally relevant. Moreover, they wanted to determine whether or not the reforms improved public safety and at what cost to youth, their families and communities, and society. The foundation wanted a fresh approach that was grounded in adolescent development rather than criminology. This is consistent with the view that juvenile offenders are not little criminals, but adolescents who've gotten into trouble with the law. Support for the death penalty in general was declining, largely due to public concerns that innocent people might be executed. Juvenile violent crime had declined for 6 years in a row, and the ADJJ believed a kids are different framework could change the narrative about juvenile offenders. They had faith in new emerging science about the teen brain that seemed to provide a hard science backup to what adolescent development experts had been saying for years, and fMRI images of teenage brain scans were a vivid and compelling way to show that juveniles as a class were less culpable for their crimes. By 2005, a coalition, including national and professional organizations, including the American Psychiatric Association, the American Academy of Pediatrics, the American Bar Association, and the Children's Defense Fund. Due to the research ADJJ was doing, they were able to establish talking points on 4 foundations. 1. That kids are different, and these differences make them less culpable than adults for the crimes. 2. The juvenile death penalty was at odds with so many other laws recognizing that youth are less mature in their judgment. 3. Juveniles' personalities were not yet fixed, and they were more amenable to rehabilitation than adults. And 4. The United States was at odds with the rest of the civilized world when it came to its use of the juvenile death penalty. A series of public opinion polls conducted in the years leading up to the U.S. Supreme Court's abolition of the juvenile death penalty showed that only about a third of Americans supported the use of capital punishment against those who were younger than 18 years old at the time of the crime. The survey results included the following. A fall 2001 National Opinion Research Center poll found that while 62% of respondents favored the death penalty in general, only 34% supported the execution of juvenile offenders. A similar 2001 poll conducted by Princeton survey Research Associates revealed that while 72% of those polled supported the death penalty, only 38% supported it when it applied to juveniles younger than 18. And a May 2002 Gallup poll found 72% support for capital punishment in general, but that support dropped to 26% for juveniles convicted of murder, 19% for the mentally ill, and 13% for the intellectually disabled. In November 2004, the Roper v. Simmons case was argued at the United States Supreme Court. The question presented to the court was whether the Cruel and Unusual Punishments Clause of the Eighth Amendment bars infliction of the death penalty on offenders who are under the age of 18 at the time of the offense. In large part, the research of the ADJJ made up the argument presented to the Supreme Court, and many of the organizations that joined the ADJJ submitted amicus briefs on behalf of Simmons. On March 1, 2005, the U.S. Supreme Court issued its ruling and held that the execution of offenders under the age of 18 when the crime occurred was forbidden under the 8th and 14th Amendments. The vote was 5-4. Justice Kennedy, writing for the majority, with Kennedy, Breyer, Ginsburg, Souter, and Stevens concurring, stated, "When a juvenile offender commits a heinous crime, the state can exact forfeiture of some of the most basic liberties, but the state cannot extinguish his life and his potential to attain a mature understanding of his own humanity." The court reaffirmed the necessity of referring to the evolving standards of decency that mark the progress of a maturing society to determine which punishments are so disproportionate as to be cruel and unusual. Based on the rejection of the juvenile death penalty by 30 states, its infrequent use even in those states in which it remained on the books, and the consistent trend in the states towards abolition of the practice, the court found that a national consensus had evolved against the practice. The court determined that today our society views juveniles as categorically less culpable than the average criminal. The court outlined the similarities between its analysis of the constitutionality of executing juvenile offenders and the constitutionality of executing the mentally disabled. Prior to 2002, the court had refused to categorically exempt mentally disabled persons from capital punishment. However, in Atkins v. Virginia, the court held that standards of decency had evolved in the 13 years since Penry and that a national consensus had formed against such executions, demonstrating that the execution of the mentally disabled is cruel and unusual punishment. Before this historic ruling, the court concluded in 1989 in Stanford v. Kentucky that the execution of 16 and 17-year-old offenders was not constitutionally barred. The court now concludes that since Stanford, a national consensus has formed against the execution of juvenile offenders, and the practice violates society's evolving standards of decency. The court overruled its decision in Stanford, thereby setting the minimum age for eligibility for the death penalty at 18. The court explained that the primary criteria for determining whether a particular punishment violates society's evolving standards of decency is objectable evidence of a national consensus as expressed by legislative enactments and jury practices. The majority opinion found significant that 30 states prohibit the juvenile death penalty, including 12 that have rejected the death penalty altogether. The court counted the states with no death penalty, pointing out that a state's decision to bar the death penalty altogether of necessity demonstrates a judgment that the death penalty is inappropriate for all offenders, including juveniles. The court further noted that juries sentence juvenile offenders to death only in rare cases and that the execution of juveniles is infrequent. The court found a consistent trend toward the abolition of the practice of executing juveniles and ruled that the impropriety of executing juveniles had gained wide recognition. When ruling that juvenile offenders cannot, with reliability, be classified as among the worst offenders, the court found significant that juveniles are vulnerable to influence and susceptible to immature and irresponsible behavior. In light of juveniles' diminished culpability, neither retribution nor deterrence provides adequate justification for imposing the death penalty. Justice Kennedy, writing for the majority, said, "Retribution is not proportional if the law's most severe penalty is imposed on one whose culpability or blameworthiness is diminished to a substantial degree by reason of youth and immaturity." In Justice O'Connor's dissenting opinion, she agreed that objective evidence presented in Simmons was similar to that presented in Atkins, but while there was no support for the practice of executing the mentally disabled, at least 8 states had considered and adopted legislation permitting the execution of 16 and 17-year-old offenders. O'Connor argued that the difference in maturity between adults and juveniles was neither universal nor significant enough to justify a rule excluding juveniles from the death penalty. Justice O'Connor did recognize the relevance of international law and expressly rejected Justice Scalia's contention that international law had no place in evaluating Eighth Amendment claims. Justice Scalia, joined by Justice Thomas and Chief Justice Rehnquist, also dissented, arguing that the court improperly substituted its own judgment for that of the people in outlawing executions of juvenile offenders. He criticized the majority for counting non-death penalty states toward a national consensus against juvenile executions. Scalia also rejected the court's use of international law to confirm its findings of a national consensus, stating that acknowledgement of foreign approval has no place in the legal opinion of this court. At the time the court made its ruling in Roper v. Simmons, there were 72 juvenile offenders on death row. All of their lives were saved from execution. Since Roper v. Simmons, some of the landmark Supreme Court cases involving juveniles have been: in 2010 in Graham v. Florida, the Supreme Court decided that juvenile offenders cannot be sentenced to life without parole for non-homicide offenses. Also that year in JDB v. North Carolina, the court ruled that a child's age must be considered by law enforcement in determining when Miranda warnings need to be given to children during police interrogations. In 2012, in Miller v. Alabama, the Supreme Court declared unconstitutional mandatory life without parole sentences for juvenile offenders. You asked us to reflect on our personal views during this presentation. I am an opponent of the death penalty for many reasons. First, I find it barbaric. It's appalling to me that in the 24th century we still justify this as a means of punishment. Proponents of the death penalty say things like an eye for an eye, but I find those ideas to be hypocritical. We know from studies that the death penalty is not a deterrent to committing crime. In studies done in 2009 and 2012, it was found that 88% of experts agreed that the death penalty was not a deterrent to crime, and that studies claiming the death penalty did have a deterrent effect were found to be fundamentally flawed. Many proponents of the death penalty incorrectly think that it costs more to keep someone locked up for the rest of their life than it does to execute them. The most significant amount of that cost comes just from the trial stage. In North Carolina, in the country's most comprehensive study, it was found that the death penalty cost $2.16 million per execution more over the cost of sentencing murderers to life imprisonment. In Texas, a death penalty case costs 3 times more than the cost of imprisoning someone in a single cell at the highest security level for 40 years. Since 1976, the United States has executed 1,500 people. We've also exonerated 166 people who were on death row. That's 166 people that were tried and convicted and then exonerated due to a violation of their due process rights or because they were found later to be factually or likely innocent. To me, this is unacceptable, and the only way to prevent us from executing innocent people is to get rid of the death penalty. We know that children's brains are different from adult brains. We know that it is harder for children to comprehend the consequences for their actions, and we know that children are more impulsive than adults. We know that in the right environment and with the right tools that most children can be rehabilitated. For all of these reasons, I support the end of the juvenile death penalty. This concludes my presentation. I hope you enjoyed it and found it informative. Thank you.